Nick, and then we'll do the second question with you. We'll start off with the fair wear and tear question. So simply put, Nick, I suppose the question really goes as, what is fair? Yeah, what is fair wear and tear?
Okay, perfect. So you made that very simple.
Yeah.
The question, I'll just frame the question. So what we were asked is basically a property's been rented out and there's been some damage to the grass on the property. And after a number of inquiries, it basically was determined that the damage on the particular property was as a result of the dogs which were on the property. Okay, and they were running around on the grass in the particular circumstance, and there's been damage to the grass. Who is now liable for the grass? And so it is a question of fair wear and tear. Now, remember that a tenant is obligated while they are in occupation of the premises to look after the premises and keep it in the same condition, or at least hand it back in the same condition that the property was received in. Fair wear and tear accepted. This is always the standard, is there's got to be some sort of allowance for fair wear and tear. Okay, so you cannot expect that a person lives inside a property and there's never a scratch or nothing ever happens to the property. At some level, the law accepts the fact that there is going to be little bumps and scrapes that happen on a property by virtue of the fact that there is a living person in that particular property, and that is allowed. Okay, a person cannot be expected to have the property in precisely the same condition, and certainly a tenant is not expected to hand back a property in a better condition than that which they were received. Okay, so it's simple. The law accepts a certain level of bumps and scrapes, which we call fair wear and tear. Now, what fair wear and tear is a question that has to be asked in every single circumstance that there is when a tenant occupies a premises. Okay, we often get questions from clients, well, what is this fair wear and tear thing? And the truth is, we don't know. It entirely depends on the facts of the particular circumstances and what we can attribute to normal usage within a property. The fact that, for instance, whenever I've had tenants move out, maybe there's some lines on the wall as a result of, an end table or the bed, which has been sitting against the wall. That is something that is fair wear and tear. Whereas, your tenant breaks off some taps while using the taps aggressively, maybe that's not fair wear and tear. Maybe that's negligent conduct in the circumstances. But the point is, this is an assessment that has to be made on a case-by-case basis to see exactly what fair wear and tear might be in the circumstances, and then you deal with that in the particular circumstances to see whether it's actual negligence and whether the tenant is liable, or whether it's something that can be just accepted as normal use. So in this particular question, we've got someone who's obviously lets out a premises. We assume that obviously the lease agreement allowed for dogs to be housed on the particular premises during the lease period. And the fact is that if you have a property where you're going to allow dogs to occupy the premises along with your tenants, you are also going to have to accept that there is going to be some fair wear and tear along with the animals that are occupying the premises. Remember, you as a landlord do not have to allow anyone to keep an animal on your particular premises. You're perfectly entitled to rent out your property with a massive garden and still say, I'm not allowing any pets on this particular premises. And the reason you do that is you know that animals come with a certain level of degradation to a property, be it scratches or digging up plants or whatever the case is. These things do happen, and it's just part of the fair wear and tear of a property of having an animal. So in a particular question like this, look, the dogs have ran on the grass to the point where the grass, unfortunately, has seemed to be destroyed, and it needs to be replaced in the circumstances. Is that fair wear and tear? It may well be, because unfortunately, or again, I assume that the lease agreement was allowed with pets. If we were in a circumstance where there were not pets allowed in terms of the premises, so pets were not allowed, then you can absolutely say that this is a circumstance where the tenant is fully liable for those damages, because they were not entitled to put the pets on. But if this is a circumstance where the pets were allowed and this is the resultant damage, there is a question about whether it's fair wear and tear or not in the circumstances. And our writer that wrote in said basically what they're looking to do is split it about half with the landlord. Maybe that is a reasonable way to assess the issue in the circumstances. But like with all fair wear and tear questions, be reasonable. You cannot expect that the property comes back in a pristine or better condition than it was. So try and work it out. It seems to me not to be an unreasonable ask in the circumstances. If as long as the property did recognize that some pets could be on the premises during the lease period.
Yeah. So yeah, thank you very much there, Nick. You've given us quite a clear definition, and obviously each matter will be dealt with. It's pretty much circumstantial and on its merit.